This is the September 10th meeting of the Civil Commitment Work Group. We've got Becca and Allison with us, and we're recording. So I think what we're going to do for today is go through the draft of the standards that we've gotten started. And I'll go ahead and share my screen, and we can see how far through that we can get.
I have to leave at 12:30, but I will be here until then.
Sounds good. And I know Becca has to leave a little early also, so perhaps we will get as far as we
great.
can.
We'll do 12:30.
All right. So the introduction is less about the civil commitment stuff and more about why we're doing this. But if anybody has any comments on the introduction, we can start there.
None for me.
Sure, works for me.
Okay. All right, so this would be more the meat of where we are. Role of counsel in civil commitment cases. The way these are structured, we have the bold print, black letter, this is the standard language, and then we have the more aspirational, may not be applicable in every case, best practices language below those. So that's what the document is going to, ultimately look like. Like some of this we may move around and some of it may not, but let's start with the bold bit if we could. Sorry, Allison, go ahead.
I'm skipping ahead a little bit, but when we're done talking about the bold part, I'll ask my question.
My only part about the bold part is the expressed interests. There are cases where you have to assume that someone is, if they cannot express or choose not to express themselves, that you're contesting hospitalization or commitment.
How do you deal with that? Like if a client can't say, I don't want to go to the hospital, what do you?
Like if they're catatonic, I'm just going to assume that they're objecting to everything.
I think, there's times where they literally can't speak to you. There's times where like nothing that they have said is in any way related to like what you're trying to talk with them about. And so I think you just default to, we are preserving all of their rights. So, I'm not, if that's the situation, like my client has not given me guidance on representation, so I'm not going to like call their family and try to like come up with a voluntary plan or something like that. But I'm certainly going to have the hearing and object and make the arguments that I think are appropriate.
Okay. So if the client cannot express their own interests, the lawyer should act to preserve all rights to their client.
Yeah.
Great. Anything else about that one?
Shouldn't it say the lawyer must be familiar with applicable statutes, case law, and local court practices? Like,
okay.
Or shall, I guess. Shall be familiar with.
Okay. All right, moving on to the non-bold bit. Allison?
Well, I think you said best practices is like maybe this won't apply, and then just like reading the first one, like that must apply. Like there's no scenario in which what is described there should not be happening. You know what I mean?
Okay.
Like you can't
I
you
do.
can't conflicts in your commitment cases either.
Mm-hmm. Okay, so let's tag that. And sometimes I'm just going to tag these things to come back to later because they're going to involve longer terms of writing than I want to do on screen in front of you all. But we can tag that to move up.
I mean, I think all of these are non-negotiables. Like I can't think of an exception to any one of these. Like if you were not doing that, I think you would be ineffective.
Okay.
I think the things that we talked about being like sort of like maybe you wouldn't be able to do that is like some situations where like the meeting within 24 hours is not possible because they're in a far-flung county and you whatever in the timelines. But like all of this is just like you must do ethical representation, which like yes, every time.
Okay. Okay, so we can work on that. My question for number 3, that seemed like something that should be applicable, but since civil commitment isn't my forte, I figured I'd check in.
I think it is. I think it looks
Okay.
a little different, considering your client doesn't have a right to be competent. So, like, what does it mean to provide them candid advice might mean something different depending on the circumstances. But I think that is definitely something that we're required to do as lawyers. I think you can leave it just as it says. I mean, I don't.
Okay.
What do you think, Becca?
Yeah, I think that looks fine.
Do we want to note that this may not be possible in all situations?
No, I think it is possible in all situations. I think the lawyer has to adapt a little bit depending on the type of client, but like there or depending on like what sort of headspace the client is in. But I don't think there's no situation in which you shouldn't be consulting with the client regarding the assertion or waiver of any right or position of the client. Like if the client is unable to do that, then you default to your being protected their rights, but you have an obligation to try to confer about that.
Okay, I follow what you mean. So you have to do it in
all
every
4 of
case,
them are
but
like
what
that.
it looks like in every case may be a little different.
But you must do those things in every case, yes.
Got it.
Yeah.
Okay. All right. Well, we will probably circle back to that one next time we meet with some alterations. So let's bump down to the second bit, the education, training, experience. Any comments we want to make on that part?
Is there any sorry, go ahead.
No, go ahead, Becca.
I was just gonna say this certification by OPDC. Is that a definite that will be in place, or is there like other relevant experience?
I think it is a definite that someone must be certified by OPDC before they're appointed to civil commitment case type. How they get certified is going to be up to them and us. There are multiple paths to certification, so we have the certifications as they exist now, the certifications as they will exist in February, and then room for consideration of other experience that equates to what we're looking for in the certifications.
Okay.
Is that what you're getting at?
Yeah.
Okay.
I'm wondering why it says a lawyer has continuing obligation to stay abreast of changes and developments in the law and with changing best practices for providing quality representation in criminal cases. Like, I'm not sure that you
Because I
need.
copy pasted.
Oh, okay. Great. With that change, I agree.
All right. So moving on to the best practices section in this.
I think number 2 is a black letter for civil commitments. And also qualifying mental health disorders, that's a criminal term that doesn't apply in civil commitment. So just lawyers should have knowledge of mental health disorders and the mental health treatment systems.
Say that again about the mental health treatment systems.
So lawyers should have knowledge of mental health disorders, their presentations, and I would just add to that, and the mental health treatment systems.
He's a Trump person that who got shot while doing this talk.
Like that?
Yeah.
Don't know how he's doing it. Like, I literally think you look at it, but doesn't sound like he should, but hopefully it's just weird.
Becca, I'm going to mute you for a second. We're getting some background noise. It sounds like somebody's talking about cases, and that's might not want on recording. All right. So lawyers should have knowledge of mental health disorders, their presentations. Should it be mental health treatment systems and likely ramifications? Like that?
Yeah, I mean, I don't know on the client's ability to successfully defend a civil commitment allegation. I mean, I don't know. Like, I think you need that knowledge in order for you to be an effective lawyer at defending an allegation. I don't know if that's what that's meant by the client's ability to defend, but
what I was thinking was you need to know how those disorders, you know, what they are, how they play out, and kind of what impact they're going to have on proceedings, if that makes sense.
it doesn't make sense, I guess.
Okay.
Like, I don't, like, yeah, I don't know what that means.
Okay. Let's say, there we go. We'll tag that to clarify what we mean there. Okay. So this was a question I had, and Becca, if you want to unmute yourself, I don't think I can unmute you, but are there collateral consequences of civil commitments that
Gun rights, you lose. It's non-expungible. It stays on your record forever. So, like when we took the bar exam, we had to report on, like, have you ever been involuntary hospitalized? And so for any type of professional licensure that comes up. I have not gotten an answer on whether or not landlords can see it. I don't think so, because it's like civil commitment records are meant to be super confidential, but nobody has given me a for sure on that. You could feasibly be stuck with a bill. Everybody who is on public insurance, which most of our clients are, but not all, do, as far as I know, have not ended up in that circumstance. But people who have private insurance where their insurance won't cover the commitment stay can end up with a gigantic out-of-pocket cost from it. And then, I mean,
Yes.
it's all of the same collateral consequences of incarceration. So, like, if you're in the hospital for a month, you could lose custody of your kids, you could lose your job, you could lose your housing, et cetera, et cetera.
Except it should be hospitalization instead of incarceration.
Okay. I will come back and fill in all of my acronyms. So this is one. What are the key agencies in civil commitment cases?
I think you got them there. I mean, like the specific like hospital systems are different county to county, but it's, I mean, it's whoever has the contract to do the state representation, and then the county behavioral health agency, because they'll have the investigators, and then the hospital system, and like whatever other treatment programs are in your jurisdiction.
What was the investigation one? The
That comes from
behavioral health?
the county behavioral health entity, yeah.
Okay.
I think it would just be alternative to commitment rather than detention and custody.
Would it be commitment and or hospitalization, or just commitment?
I think commitment and detention. I mean, because people are detained in the hospital prior to their hearing. So feasibly, you could be arguing for somebody to just be released from the hospital instead of avoiding commitment entirely.
Okay. And that last one fair?
I mean, commitment is like, yeah, that's true, but like not all of the people that we represent in commitment hearings are indigent. Like, I'm not aware of any county doing a financial qualifier before appointing counsel for it. So, I mean, and also like, if a person is committed, then the hospital is technically responsible for doing the discharge planning, and like we don't really have any influence over that at all. So I mean, I think this kind of 7 is kind of subsumed under the umbrella of 6. Like those things are part of the, like, perhaps here's an alternative because I'm aware of these services that you could be connected with, but we don't like serve that same function in a commitment case as we do in a criminal case.
Okay. So it could be something that you would go through with clients in preparation.
I mean,
it's commitment hearing, but not something you'd help them plan for post-commitment hearing. Is that what you're saying?
I mean, like, it would, like, bearing in mind that a commitment case is a maximum of 10 days long. So, I mean, and it's also like in conjunction with this other like massive social service agency. So like whatever information I could give to a client about that is not going to be as comprehensive or helpful as like the information that the social worker at the hospital is giving to them. So like we talk about that in terms of like, can you meet your basic needs? Like, do you know where you can go for housing or for shelter or whatever? And so like having a sense of that, communicate that to people and get a sense of like whether they're able to retain that information. But like there's not there's really no opportunity for like making referrals and like treatment connections and things like that.
Gotcha. Okay.
I don't know, Becca or Bailey, if you have different takes on that.
I definitely would say that's one of the like best practices, ideal world. Yes, but otherwise it's not going to be part of what most attorneys are able to do.
I'm sorry, I came in partway through. I had a client meeting run late.
Not a worry, Bailey. We were talking about the aspirational best practices section of the education, training, and experience civil commitment lawyers should have. So really, these are things we'd like them to know, but are not absolutely necessary to do the job. We were discussing the last of those and kind of whether or not it ends up combined with the second to last of those.
I think number 5 should be in the black letter. That is a non-negotiable. Like, you have to know about collateral consequences.
Okay.
I definitely agree with that.
Okay. Anything else on this section before we move on?
I mean, I think at minimum in number 7, like, you should take out defendants, like indigent patients.
Whoops.
Maybe.
Say class. Okay. Can do that. So I do want to be cognizant of time because I know Allison had a 12:30 and Becca has some 1:30 hearings to prep for, and it is 12:29. So Allison, thank you. Good luck with your next thing.
Thanks, everyone.
Becca, Bailey, do you want to stick around and maybe try to get through one or two more? Or Becca, do you need to go? And Bailey, I don't know what your scheduling this afternoon looks like.
I can do one or two more.
Okay.
I could probably do one or two more as well.
Okay. Obligations of counsel regarding workload. It's essentially pulled from the rules of professional conduct. But anything on either the black letter or the best practices on this one?
I think it's a little funny, the withdrawal possibility, just because it's not a criminal case and it's such a expedited timeline that you're never going to have the opportunity to withdraw from a civil commitment case.
Okay.
So it all has to be in advance of taking the case.
That makes sense to take that out, I think, then. Sometimes I forget that these things are 10 days long. Anything else on that one?
Lawyers should not overly rely on other lawyers to cover their appearances. I think if we're talking best practices, it should be that the lawyer appears for most often it's just one appearance. So I don't know when it's lawyers should not overly rely on other lawyers to cover their appearances. I don't know when that would really apply.
I agree. I think just take out that middle line.
Okay.
I think some offices do use legal assistants to do initial interviews, but I wouldn't even touch on that. I think I would just say critical stages, attorney has to be there.
Yes.
This has caused some discussion in other groups. Are courts doing civil commitments remotely often?
Yeah, I think at least some part of the process. A lot of times clients don't want to come and be personally transported. In Washington County, there's a provision that allows for it to occur by video. And the practice is that it's up to the client to decide whether they want to personally appear or not. I think, yeah, I think that kind of depends on the jurisdiction, but where possible, it should be a client decision.
Okay.
In Marion, it defaults to it defaults to remote unless that person is in jail. If they're in jail, they're transported unless they can't be. I agree that it when possible, lawyers should appear in the same manner as their client. I've had circumstances where the hospital did not allow me to have contact in person with my client, or it would be through glass. And in those circumstances, I've had to appear separately from my client just so that I could, I could appear. So it's complicated. It's not my preference that hearings are remote. I think the court should be required to come to the patient, especially when the patient's at the state hospital. But that's just because the question is, what is the standard? Our default is in person, or excuse me, sorry, our default is remote.
Okay.
That might be a thing where it's like the lawyer should know in their jurisdiction whether the possibility for like bedside hearings are available or in court or what.
Yeah, that's good.
Okay.
I usually appear not with a client, like I'm there in person in court, and then the my client is at the hospital, and usually the medical practitioners are by phone or video.
Okay. We'll just tack in that lawyers should be aware of how their clients can appear. I think that sounds like that covers what we're talking about. Yes? All right. Client communications. Let's cover what's written and then we'll come back to the comment up here. So a lawyer must meet with client within 24 hours of appointment and attempt to conduct an in-person interview with the client, and should thereafter establish procedure to maintain regular contact with the client in order to explain the allegations of the process of commitment proceedings, address the ongoing needs of the client, obtain necessary information from the client, consult with the client about decisions necessary for the representation, conduct a conflict check, and respond to requests from the client for information. I do want to come back to the conduct a conflict check because it sounds like that really should happen sooner than the rest of this is talking about. But other than that, anything on that section that we want to talk about? Okay.
I would just say
Um,
conflict check at time of appointment.
Okay. I think.
For in Marion County, like we're not able to do the conflict check. I mean, we can, but we have to do
Mhm.
a second conflict check. I mean, yeah, we should be doing that. We also have to do a second conflict check when the report comes in, which for many counties, appointment and the report coming in happen at the same time.
Okay. So I'm going to figure out where to put that then. Um, but other than that, does that kind of capture what we're talking about seeing the client as soon as you can or within 24 hours? And then I think,
So.
yeah. And down below, for clients that are detained outside the lawyer's primary county, lawyers should consider having counsel in the county where the client is detained appointed, or conduct the initial interview with the client to satisfy the 24-hour standard. So those first two under best practices, does that take care of the concern about out-of-county clients, do we think?
I think so.
I think so too. And I'm just have a slightest hesitation about making it a bright line rule, just unless, extraordinary circumstances make it impossible, just sometimes people
Oh,
are in, um, isolation or something that makes
yeah.
meeting,
Yeah.
not
I mean,
possible.
we are calling these bright line rules, but I mean, I think every lawyer knows there's always going to be an exception to the bright line rule where it doesn't apply. Um, and the way I think we're envisioning these are going to be things that raise flags for us. So, um, like you should be doing this, yes. If you don't meet the client within 24 hours, it will pop up a flag and somebody will say, well, why didn't this happen? And you will say, well, 'cause the client was in isolation and the hospital wouldn't let me meet him. And we say, oh, okay, thanks. And then we all move on. So I think we're fine to say you have to do it and not to include all the possible exceptions that we would consider.
Okay.
But the point is well taken. So then to the side comment, and then we will probably break for the afternoon. Do we want to add something about seeking appointment early or early appointments in the case and a lawyer's responsibility in that regard? I mean, do we think lawyers should be pressing for early appointment in civil commitment cases?
I'm hesitating, and I think the reason I'm hesitating is, I mean, my straightforward answer being yes. I hesitate because I don't know what relationship attorneys across the state have with their local jurisdiction. And I mean, I had a sit down conversation with my PJ a couple or 3 years ago now at this point to get day one appointments. And I hesitate to make it like a bright line. You must push and agitate because there isn't a right to it under, I mean, it's an interpretation of the statute. And I think that should be if I were to be so bold, OPDC and OCDLA, that I think is their responsibility, not necessarily the individual attorneys. I think the individual attorneys could ask, but there are counties that have made it extremely clear they don't intend to do that. And I just worry about encouraging people to do something that could damage their relationship with their local court. And when I think it should be the responsibility of other agencies, if that makes any sense at all.
That makes sense. I had flagged it because of the discussion around the day 1, day 0 appointments. And I confess I don't follow all of that. But I wanted to be sure that we had a chance to really talk about whether or not that should be something that was included.
I don't know that I understand that completely. I mean, wouldn't it possibly overwhelm an attorney to get all of these appointments really early and then they don't pan out into anything that's gonna, I mean, if these folks are getting discharged on day 3 or they're making other decisions, I don't know. I don't know what the volume is that would change.
It's something, I mean, and Becca, we discussed this yesterday as well, just so you know, Jordan, there's another group of us that were discussing this. And for example, in Multnomah County, it would be possibly impossible just because of how many cases come in. But there are jurisdictions where it does make sense. We've been doing it in Marion, as I said, it has to be like 3 years now that we've been doing it. And there were only like weeks, like at a time, like maybe a week out of every 3 months where it was a lot for me as a singular attorney. Now there are 2 of us and it's pretty manageable for what we have in Marion, but I don't know what it's like for folks in other counties.
Okay.
It might just be a best practice again to like talk with the county health about what their process is or know who, you know, if it becomes an issue. I don't know. I'm always glad I don't get them till later.
Something like that. Know the process for appointments and seek earlier appointment as needed.
It's hard to say as needed. Because I don't know if I would use the term as needed.
Okay.
I don't know how I would word it.
Maybe it's just other avenues of communication. Like sometimes, you know, you'll get a phone call and they'll be like, there's this woman and we're working with her and we're only on day 1, but it's kind of a more informal heads up process with investigators. I don't know. But it's not usually on the attorney to make that call.
Okay. Well, let's do this. It is 12:45. So let's leave that as is with the notes that I've got. If you all will think about that, we'll pick up there next time around in 2 weeks. Does that sound good?
Sounds good. Thank you.
Thank you.
Sounds good. Thanks, Jordan.
Thanks, Bailey.
Mm.